Thanks for joining. My name is Akshaya Kamalnath. I'm a senior lecturer here at the Australian National University College of Law. I'm very pleased to be moderating this session where I'm hosting it on behalf of the private law research group, which is headed by Associate Professor Pauline Bomble, who unfortunately couldn't make it today. She's teaching at the same time, but we had scheduling issues because we're trying to schedule across time zones. But we made it. I will not take too much time introducing our speakers. We have their extended bios on the event page, but very quickly, the speaker, Alan Koh, is an assistant professor of business law at the Nanyang Business School, Nanyang Technological University in Singapore. His research focuses on comparative law and comparative corporate law and governance. Our two panelists are Professor Martin Gelter and Professor Pamela Hanrahan. Professor Gelter is a professor at Fordham Law School who has extensive expertise in comparative corporate law and governance. Professor Hanrahan is a professor at UNSW Business School. She also holds other concurrent positions. She specializes in corporate law, corporate governance, financial services regulation, data governance, and business ethics. So I'll give the floor up to Alan, and we're looking forward to hearing from all of you.
Thank you, Akshaya, for the very kind introduction. I'm going to now share screen, which, let me see, it should work since we just tested it. All right, so here we go. See. Okay. So, good morning, everyone. Just thank you very much for coming to this discussion about my forthcoming book with Cambridge University Press, Shareholder Protection in Closed Corporations. So this cover image is taken from the cover image I commissioned for the book. And it's not really anything to do with the topic, except it's to portray a very small business, typical cafe, which apparently is the dream of millennials and also Gen Zers who don't see a future in wage slavery. Not that it's actual wage slavery, but the modern equivalent of it. So this is pretty much the focus of today's topic, the problems arising in closed corporations. So let me get to the overview. So for my 15 minutes, which is very short, I'll focus only on giving the broad overview and resist the urge to delve into the details that pretty much was my life for several years. I'll begin with introducing very briefly the basic problem of why shareholder protection is necessary in closed corporation law, and also introduce the concept of withdrawal. But I think because it's such an important and key concept here, I'm just going to introduce it right now, but I'll come back to it again later. So for now, by withdrawal remedies, I mean legal solutions that enable a shareholder to voluntarily exit a company with a sum of money in hand. I'll explain very briefly why withdrawal is not just timely as a subject, but essentially timeless. I'll also go through the methodology, very briefly, and introduce the comparative framework that sets out the aspects of withdrawal remedies that I looked at, but without delving into the results. What I'll instead spend a bit more time talking about are the patterns of convergence that I've observed in the 4 jurisdictions I've studied, and then talk very briefly about the key features of my proposed withdrawal remedy, which applies certain insights, including from behavioral economics. I'll then conclude with very brief remarks. So on to the main problem. This is nothing new to any corporate law scholar or even corporate law student who still remembers what they have studied. So closed corporations, which may be slightly unfamiliar term, means unlisted private companies that are closely held with relatively few shareholders. These are an important economic presence in many jurisdictions, notwithstanding the fact that they are not really prominent necessarily, kind of fly under the radar. We don't really have high-level international conferences about them, but they're important nonetheless. Being a minority shareholder in a closed corporation is perfectly fine. It's a way of doing business, investment for many people, and things can go great, they can be profitable and harmonious until they are not. So what happens to minority shareholders when things go wrong? Put very simply, at the risk of oversimplification, the status as a minority means that they have no ability to force their will, short of using non-legal methods, pretty much, upon the majority or the controllers of the company. Being a shareholder of a closed corporation also means pretty much by definition that they have no market at all for their shares or membership interests. Because of these reasons and others, corporate law scholars generally, except for a few fringe, mainly American figures, accept at some level that the law needs to protect minority shareholders. The real debate is about what the law can or should do, and the extent to which shareholders may nonetheless contract around or out of such legal protections. So what is withdrawal within this context? Now, again, withdrawal is a legal solution that offers justifiably aggrieved shareholders in a wide range of situations, a way of exit from the company without destroying the company as a going concern. This is the critical difference between withdrawal and, say, judicial dissolution or winding up, which is the even more traditional remedy for intra-corporate dissension. This regime, right, comprises two parts. The first is voluntary exit from the company. This severs the relationship between the closed corporation and the shareholder. Because of this, withdrawal is a permanent solution to intractable conflict between shareholders, or to some extent between shareholders and management or controllers. The second component of withdrawal is the receipt of a sum of money. This monetary claim is the critical difference between a legal solution that is palatable to the withdrawing shareholder, and the shareholder just basically pretending like they never were a shareholder and the investment is basically written off. Right? That's the difference. So if we look at developed jurisdictions across the world, we'll see that withdrawal is pretty much ubiquitous. Right? In the Anglo-Commonwealth, right, I think this is where we are situate remotely, even though those situation is a bit difficult, right? In the United States, save for some states, including Delaware, which I must flag out as a sort of a big exception, right? In Germany, right, they all have it in some form. In every major Anglo-Commonwealth territory, right, whether the UK, Australia, Canada, Hong Kong, or Singapore, right, the oppression or unfair prejudice remedies are widely acknowledged to be pretty much the most popular shareholder remedies like ever designed in the history of our laws. And specifically, it is the share buyout, right, usually of the unhappy minority shareholder by the remaining or at fault controlling shareholder or majority shareholder, is the most popular and the most useful of all the reliefs that can be granted under the oppression or unfair prejudice remedy jurisdiction. Even Japan, which for the longest time had no withdrawal remedy for its closed corporations, introduced something in connection with a new closed corporation form sometime during this century. But why this topic now? Why 2022? Well, to be precise, I started writing this in the mid-2010s, but so why mid-2010s? Now, first, individual withdrawal remedies in individual jurisdictions is not a new thing, right? With some exceptions, they've been usually there for like at least a few decades. So it's neither like new, but it's not exactly old or passé either. This is because there are timeless issues in corporate law. Closed corporation shareholder conflict is just a fact of life. Descriptively, from all the evidence we've seen in cases, all the debates we've had, it's quite clear that it has always been and will continue to be a problem, provided that closed corporations play a significant role in the economy. And this is set to continue for, well, until, of course, climate change catches up with us and ruins all of us. But until then, it's a fact of life. Having said that, the book's timing is also pretty good, but I can't take credit for this. Now, when I first started writing in 2015, not much was happening, except to say that the Societas Privata Europea proposal in the EU just was just killed off or abandoned. But shortly after that, a couple of initiatives still continued. One was the European Model Company Act, which was released by a group of scholars. They do contain a provision on this. So it's acknowledged as it's an important part. And they didn't really have to include it because many other legislative proposals before that didn't bother with this. UNSW also released a legislative guide in 2021 containing one recommendation specifically about withdrawal. And I'm told by a good colleague on that working group that the nomenclature itself, the fact that UNSW adopted the word withdrawal, was in part related to the fact that I had already started publicizing my work sort of around then. So maybe I can take a little bit of credit for that. Right. But most recently, I discovered that even Poland, right, had introduced a close cooperation form with a very sophisticated, by comparison, withdrawal regime. So all I'm trying to say is, even as there are bigger questions in our field, and I'm not denying that, right, such as sustainability, corporate purpose, climate change, right, withdrawal is still a live issue. So now, a few brief words about methodology. Right. I looked at the four largest developed economies: the US, UK, Germany, and Japan. Now, as a comparative, we all must justify our methodological choices, so I shall do it very briefly. Now, the official story I pitched to the publisher and the proposal reviewers is that these four jurisdictions are, they're large, they're important, they exert influence on other jurisdictions, right? And of course, nicely span the common law, civil law divide, which is of course a belabored distinction, but it's still useful for purposes of categorization. And also East and West, because I'm kind of stuck between worlds, right? Like quite a lot of us who have crossed borders to pursue our lives. Right. Now, personally, I have liked to look at Korea, Taiwan, France, Austria, Switzerland, and the Nordic states for various other reasons, but I just don't have the language faculties and or the access to resources at the time. I'd love to do it in the future, if possible, if there's still something left to be said, and I think there will always be. Now, nonetheless, the idea is to strike a reasonable balance between breadth and depth, and the structure of the book itself tries to balance cross-jurisdictional conceptual coherence and intra-jurisdictional consistency. So I try to draw on each jurisdiction's own sources in their own language as much as I can, and I try to present withdrawal from a quasi-insider's perspective. The idea is to have it be recognizable to a jurist native to the jurisdiction while remaining approachable to readers trained elsewhere. And of course, as my first book, it definitely went overboard on the details and fell short in others, but I'll endeavor to learn from my mistakes. So the comparative framework, again, I'm not going to go into the details, but this is a list of things that I looked at. So if you think about it as sort of the contents page of each chapter, and of course of another overall chapter summarizing my findings. And here are the elements. So of course, it's important to understand the evolution, the history of anything you're looking at. I think it's impossible to take a snapshot and just call it a day. It's important to follow how things evolve and what the actors and what the juridical basis according to which withdrawal remedies have evolved. Generally, we're talking about statute versus judicial precedent, unwritten law, Richterrecht, right? That applies especially the case for Germany. Now, the details would be of things like what are the grounds? That is, what are the circumstances under which withdrawal would be granted by a court? So I identified 4 types of scenarios. The other element, which is pretty important for the purposes of distinguishing between the Anglo-American model and the civilian model, which I'll talk about in just a bit, is who would be liable to pay that monetary claim to the withdrawing member. The third aspect is the extent to which the target jurisdiction's withdrawal regimes financially protect the withdrawing shareholders' interests. So does it include compensation for harm, right, in a reflective loss sense, or it doesn't? So, and the last is the, again, drawing on the critical tensions between contractarianism and the notion that law should protect weaker parties, or at least offer certain rules and or principles. I look at the extent to which shareholders or parties more generally can contract around or out of the legal withdrawal regime. The patterns, right, which emerge from this analysis, right, and based on the evolution of withdrawal remedies in the 4 jurisdictions, led me to conclude that convergence has occurred in this field. Now, specifically, I call this spontaneous functional convergence, and I'll talk about this a bit more later. And I also talk about the two classes of approaches, which I'll call models, ideal type. Sorry, I usually use a lot of German terminology because I find it's a lot clearer. But I'll talk about models in the subsequent slides. So first, about the convergence related aspects. So I hope I'm not over time yet. Here are some key findings. Now, first, which actually surprised me, was that the 4 jurisdictions almost completely independently developed their withdrawal regimes. There is no foreign influence, with one sort of very small exception where some very ancient English law was considered by 1 or 2 American states. But the rest of the US states just kind of came up with it themselves. So it's very amazing, right? There's no interaction whatsoever, despite quite a bit of scholarship, but very little comparative scholarship right from the beginning. In the in terms of the legislative creation of withdrawal remedies, there's no evidence whatsoever, pretty much, in Germany, the UK, and Japan in terms of foreign influence. Now, looking at these 4 jurisdictions also enables us to sort of eliminate the effect of legal diffusion. Now, as a citizen of post-colonial state, and as many of my colleagues are, from whether you are from India, Australia, or other parts of the Anglo-Commonwealth, by definition, we are recipients, right, of English law at various times. Now, if you cut out the influence, right, so it kind of makes sense that there should be no foreign influence. But if you take into account how legal diffusion has worked, it is extremely fascinating, right? Because the convergence that we see in these 4 jurisdictions is spontaneous. It is not planned or coordinated like things like codes of corporate governance or stewardship codes. This is completely different. Now, the differences in the form that withdrawal is taken also mean that this is not formal convergence. It's not full convergence in the Gilsonian sense, but rather functional convergence. Now, I alluded to diffusion to places including Australia, right? So the fact that it has diffused everywhere, but for some reason has pretty much persisted and to some extent taken a life of their own, does point to withdrawal being, if not the only right answer to the problem of close cooperation law, it does point to it being amongst a range of right answers. So the last slide, right? So the models that I've alluded to. First is the Anglo-American, or what I call the corrective model. Now, what do I mean by corrective? So the general features of this model would be, right, withdrawal requires clear attribution of fault to somebody, right? So usually to the controlling shareholder or sometimes management, right? That requires an element of fault, but it is also more powerful as a remedy from the minority's perspective, in the sense that the protection is stronger. That's not to say that it's well, comprehensive in its coverage, because in the Anglo-American corrective model, shareholders in situations where fault cannot be clearly attributed, right, or where the withdrawing shareholder is at fault, is met with pretty much a lack of sympathy, right? The courts don't like this kind of plaintiffs, right, in that sense. Now, by providing relief for fault grounds, pretty much fault grounds only, withdrawal does serve a compensatory function because the party at fault is liable to make the party whole again, including through the compensation or reflective loss. A side effect of this could be deterrence in that controllers whose acts and conduct can affect the fortunes of the closed corporation and of the other shareholders who might get very aggrieved would, on pain of substantial personal liability, because the financially liable parties are the controllers themselves, right? They would have good reason not to abuse their powers or use them in a prejudicial way, at least not without good justification. So that's a oversimplification of some of the details, but it captures the essential essence of the Anglo-American model, or the corrective model, to be more precise. The other is what I've struggled between quasi-insurance and insurance models, because one reviewer basically said, "Oh, quasi-insurance is." I responded to one review by saying, "Oh, quasi-insurance probably is better," but essentially the metaphor is the same, right? The metaphor of insurance is that it covers a wider variety of scenarios, but there's a drawback, right? So I'll get to that in just a bit. So in Germany and Japan, the insurance model means that it's possible to get compensation not just when fault is involved, but also where there is no fault, or where the fault is somewhat unclear, for example. Now, the good thing is that shareholders who have fallen on hard times or have just fallen out with the other participants in the closed corporation enterprise may take comfort in the fact that there is a legal solution to this, right, without having to prove that someone was really at fault. So in that sense, it's like no fault divorce, which is, again, something that's become quite common across the world. What the problem, the limitation of this is that the remedy is narrower. It is balanced against other interests, other stakeholder interests, and its enforceability is much weaker, is subject to things like capital maintenance, which is an interesting obsession of certain jurisdictions, more doctrinally oriented scholars. So that's actually a legal obstacle to enforcement, and we cannot underestimate this problem. To summarize, right, German and Japanese withdrawal regimes, the quasi-insurance model, are more inclusive but contingent forms of shareholder protection. That's where the insurance metaphor again kicks in. It's like the corporation's own resources are a little bit like a quasi-insurance fund, right? It protects shareholders against certain vicissitudes of life, albeit only partially, right? Because, and again, insurance never compensates you in full, right? But it's better than nothing. That's the idea. So I'm just going to talk about the model. Essentially, the model is a response to the fact that both the corrective and insurance models have gaps. One is narrow but deep. The other is broad but shallow. So why not have something that is broad and deep? So that's the general idea. So we want to have, I'm greedy, right? So I wanted to have the best of everything. So I combined everything together. But I needed to address the contractarian objection, which is corporation law is fundamentally partially contractual. Parties should be free to organize their business affairs. What are you going to do about that? So there's a question as to whether parties should always be allowed to contract out. And my response to that is, it's not always a good thing, because sometimes they contract out for bad reasons. Sometimes they don't even have reasons, which is even worse. So the notion is that, yes, we want people to organize their affairs, but preferably for good reasons. So that's a level of, I guess, paternalism involved here. So the solution would be to combine the two models, deal with their respective weaknesses, and to regulate contracting out. So I came up with a 3-tier system of rules and standards, which draw on primarily Ian Ayres's work. So here goes. The absolute minimum core, mandatory core, contains key corrective functions, which mostly correspond to things like bad faith, misconduct of the controllers, and intentional harm. So really the most egregious of corporate misconduct will be mandatory, not subject to contracting out because of moral hazard reasons. The second tier of norms, which cover some of the more peripheral corrective functions, such as breach of reasonable expectations, and as well as insurance functions, which is basically non-fault type breakdown scenarios, they're protected by sticky defaults, which permit parties to contract out, provided they follow certain requirements. So these requirements are there to ensure that they have a good reason, that they think about what they're doing and why, and some basic procedural guarantees such as independent legal advice and access to information. So I think this is quite unobjectionable. Fundamentally, it's just a bit more tricky to contract out because you need to look at what you should be doing. But it's probably a good thing because it gives parties a good sense of why they're doing things, and that's more important than anything else. Right. And lastly, withdrawal at will, which is something that Japan actually has, which is quite cool. A few US states also have it. I'll just put it in as a simple default because, okay, if it really doesn't work for you, just contract out of it. No biggie, right? So the model remedy itself is written a bit like a model law with 36 provisions. So that's why I confess that I went a bit overboard. That's why I'm not going to go into the details, but it's not targeted at any jurisdiction in particular, because I wanted to keep this because I truly believe that withdrawal is a ubiquitous solution to a ubiquitous problem. So it should float there, at least as potentially useful to anybody, right? Any jurisdiction. It can be used to guide legislative reform, of course, but also as a soft law guide, which is unparalleled in its, complexity for anyone who really wants to solve the problem from first principles. I have no illusions about it actually happening, but that's the aspiration. And again, it's also meant as a checklist of issues. So if you're a very good, highly paid transactional lawyer, look at the list and you realize, oh, there are actually a lot of issues that maybe can be addressed, and maybe you want to take your client's instructions on it. If there are no instructions, then it's at their own risk. But they can't say that you've not warned them. So it's a great way to protect oneself. So concluding thoughts, this is the last slide. So 3 points. And the first point is really important. Withdrawal has been around for a long time and will always be an important part of corporate law, regardless of whatever is in fashion, or even if the planet is ending. Until the planet ends, this is a problem. We need to remember this. And second, the 4 jurisdictions have developed different approaches, different models of withdrawal, each of which are good and bad in different ways. So what this book's contribution is, among other things, I hope, is to propose something that fixes it all, like combines everything and addresses the fundamental tension between the law's function and the role of party autonomy in enterprise law. And with that, thank you very much, and I look forward to engaging Professors Hanrahan and Gelter and the audience in the following discussion. Thanks. And with that, I'll stop screen share.
Thanks very much, Alan. That was really interesting. Is that okay, Pamela, if I ask you to hear from you while we wait for Martin to reconnect?
Yes, I'm very happy to. I was going to just make some comments for our Australian audience to put this into context. Is that okay?
Yeah, perfect.
All right, great. Well, I'm going to try to share my screen, although with great nervousness. Right, do you have my screen and can you hear me okay?
Yes.
All right, good. Now, I'm going to just talk for about 5 or so minutes because I want to leave enough time for conversation at the end. But I certainly wanted to echo the remark that was just made about what an extraordinary project this is for a number of reasons, not the least of which is there are many people on this call who know how difficult it is to do research across different legal systems, let alone different languages. And because closed corporations, a topic very dear to my own heart, aren't the subject of very deep academic analysis, I know that Alan will have been working mostly in original language materials, which is just quite astonishing. So congratulations, first of all, on the book. I just wanted to say something briefly about closed corporations to remind the Australian audience. First of all, I've just put the working definition sort of internationally of what constitutes a closed corporation up there. And I think characteristics 3 and 5 are quite important in this discussion. So a small number of shareholders and typically some level of shareholder participation in management. This kind of distinguishes them from other types of corporate vehicles. I also wanted to mention, and I have mentioned it to the President of the Australian Law Reform Commission, that we did have a crack at specialist closed corporations legislation in Australia at the end of the last century. So you have to be quite old to remember that we had a go at it. So this was amongst a group of bills that were proposed at the time when our Corporations Act, it became the sort of overarching corporate law framework for Australia. It was proposed to carve out closed corporations and create a specialist regime, and that failed with the constitutional difficulties that we had around the enactment of this legislative package. But I've always been very much in favour of it. I think Australia has too much and too complicated corporate law for the vast majority of entities that are subject to it, and I'll talk about that in a minute. So I always hope that there'll be an opportunity to revisit this, and I think if we can persuade the President of the Law Reform Commission at least to mention this aspiration in the context of her current review designed to simplify and streamline Australian corporate law, then we may give Alan's proposal its first legislative enactment. You never know, because I think it's an interesting solution, particularly the mandatory, the sticky optional, and then the optional model. I think that's quite attractive for a number of reasons. But anyway, so we did have a plan to have closed corporations legislation in Australia. It was abandoned a quarter of a century ago, but you never know, it may come back. And for those people who are interested, I've just put a link to the explanatory memorandum from the old bill there in the slides, which no doubt we'll share a little bit later. So I wanted to say something just briefly about the Australian context, but I always like to ground this very strongly in the lived experience of people who use this corporate form. So most SME in Australia uses the proprietary limited company, a proprietary company limited by shares. Australia used to have a wonderful reputation for innovation in corporate form. The proprietary company was an innovation of the Victorian government more than a century ago. We've slowed down a little bit on that, which I think is a shame, but there you go. Its really only distinguishing feature now is that some investor protection and disclosure measures that apply to public companies are disapplied in this context, but there's not really a conceptual difference. And for example, all of our public law about governance, because our directors' duties and so on are all public as well as private law, they apply contextually, but they do apply against both proprietary and public companies. So there's no kind of conceptual difference really between a public and proprietary company in that deeper sense in Australia. There are about 3 million proprietary companies in Australia. Not all of them carry on business, but when I did the report for the comparative law project 8 years ago, I asked ASIC to tell me what those proprietary companies looked like. And so I've reproduced these statistics. They're old, but they're hard to replicate, so I've put them in. About half of our proprietary companies in Australia have only one shareholder, so that's not an issue. Then we've got, forgive me, it's under my little picture, 38% have 2 and the remaining 13% have more than 2 shareholders. It's probably still similar to what it was then. We're mostly talking about natural persons, which I think is interesting for what I'll say in a minute. 12% have corporations only as shareholders, indicating that they might be operating subsidiaries of corporate groups, but the rest are, we're clearly talking about private relationships between people here, and I think that's important. I will just mention for the Australians, we've now got this little complication that some proprietary limited companies in Australia have CFSF shareholders. Apologies to everyone else, that stands for crowdsourced funding. There's a new capital raising mechanism in Australia that allows non-insider shareholders in some proprietary companies, which may affect our analysis here later, but I'll leave that to one side. So I think I agree absolutely with Alan that the withdrawal is a ubiquitous solution to a ubiquitous problem in these closed corporations. That is true in Australia. And of course, we have the court-ordered corrective model that I'll talk about in a moment. But I also just wanted to emphasise that court-based solutions to problems of these types of disputes are unsatisfactory for a range of reasons, mostly linked to access to justice. So in the Australian context, there's no sort of small business dispute resolution type framework. And I did a quick search before we started talking, and I saw that there are hundreds and hundreds of oppression actions, I'll talk about in a minute, that involve small businesses spending vast amounts of time and money on lawyers, and courts spending vast amount of time resolving what the judges behind the scenes refer to as the family law jurisdiction of corporate practice. They're typically, you know, like Anna Karenina, you know, all of these families are unhappy in their own way, right? So it's not a jurisdiction where it's easy to resolve these disputes. They're very fact heavy. You're making a whole lot of judgments that are essentially value judgments on the part of the court about where, because it is a corrective model and it's a fault-based model, where the fault lies and how you might effectively compensate for that. So I did just want to mention that negotiated withdrawal, for practitioners at least, has to be the first port of call. Dealing with these things, so using Alan's model as a checklist when you're setting up a venture to say to people, I know everybody thinks like married people, right? Like when people get married, they never think it's going to go badly. But if you think through these issues, think about shareholder agreements, think about put and calls in the Constitution, think about the basis on which you might negotiate exit strategies, whether that's, you know, valuation and then giving people different options. We have the same, slightly simpler, but the same reduction of capital difficulties in exiting shareholders, share buybacks, reductions. Schemes of arrangement are technically possible, but run into the problem that I've talked about with cost and complexity on court-based solutions. So our corrective model withdrawal provision, of course, is section 233 of the Corporations Act. It is a fault-based model, and the calculation of the payment received by the exiting shareholder is based on a kind of compensatory model. So it's clearly in that group one, but it does require lengthy and expensive court proceedings to arrive at what is sometimes feels a little bit like the judge, you know, wetting their finger and holding it up in the wind to see where the balance lies. We do, of course, have steps in that court process to encourage people towards mediation, arbitration, and so on before reaching final dispute resolution. But it is a system that is heavily weighted towards this type of approach to dispute resolution. So my comment or observation for us to think about in Australia would be, yes, we have it, and I think we're so comfortable with it. You know, we go, well, yes, the oppression remedy allows for a court to order for the purchase of shares either by other shareholders or by the company itself, subject to adequate protection for creditors, which is another issue in Australia because of the impact that this can have on the company's capacity to meet its obligations to creditors. But subject to those two things, yes, we think, oh, well, we've got that done and dusted in Australia, right? We have the oppression remedy and people use it and so on. But my two observations would be, I'm not sure that it is as user-friendly as it could be if we had a more targeted and tailored closed corporation regime in Australia. And I'm not sure that we have solved the access to justice problems in this model, and you know, alternative solutions should very much remain on the table. I'll stop there and we'll see if we have our other commentator back.
Hopefully he'll be back before we finish, but maybe I'll exercise moderator's privilege and ask a question before throwing it open to everyone else. So I remembered while listening to your comments, Pamela, that there was a proposal in the New Zealand context, maybe that was Susan Watson, but she was saying how in close corporations in family owned firms, especially in that kind of context, mediation may be a good first step. And is that the direction you were going in when you said negotiated withdrawal?
Yes, and I haven't talked about the interaction between this and the rules that apply when in dissolution of marriage. I think it's a very significant practical problem, the intersection between family law and corporate law. There are significant feminist jurisprudence implications around what happens in the breakdown of family companies that I think perhaps that's probably a discussion for another day, but you know, where you end up in these businesses. And that's why those statistics are really important. It is likely that, and perhaps if there's anyone on the call who's interested in doing it, I think some deeper analysis about the composition of the shareholders of proprietary companies would be really valuable to understand what relationships that those parties have with each other that are on top of or in addition to being business co-venturers would be really interesting, because I'm not sure why we persist in pretending that family businesses are, you know, corporations that can just have corporate law lumped on top of them and ignoring all of these other issues. I think it's a really prospective area for research. And I think one of the things about Alan's model that's so interesting is when you start to think about introducing that kind of sticky default around those other, you know, not corporate misconduct, but other reasons why relationships of trust and confidence might have broken down, then you do start to open up that conversation. And I think that's really important.
Hi, Alan. Thank you so much for that very insightful presentation, and also for Pamela's comments. One question I would like to ask you, it's really a very basic clarification, Alan. The simple default model that you mentioned there, was it part of the GK regime which was introduced in Japan? And one more very general question about KKs and GKs, because I read one of your articles, I think it was written in 2020, where that was like the first introduction I got into this topic, where you made a comment, more like an observation, that at that time, the KK model was much preferred over GK, even though the withdrawal remedy was there. Do you have any recent observations as to that particular point?
Thank you, Rangika. I'm surprised that anyone even reads my 2020 article anymore. So I do summarize this quite a bit in the chapter on Japan in the book, which will be published sometime this month online. But just to take up the theme, Rangika's first question, whether the simple default is part of the GK regime introduced in 2005, the answer is yes. But there are earlier examples in the US where even the earliest LLC, limited liability company statutes, included withdrawal at will. Of course, I don't want to get into the withdrawal versus dissociation distinction right now. I think Gelter probably has to teach, Martin has to teach it in his classes, right? If we talk about LLC law, but the simple default idea of that actually comes from that, because it's quite well known, even though there's no empirical evidence as such, that parties routinely contract out of the withdrawal at will default in Japan. So it's probably not a good idea to go against this practice. So make it not too difficult to contract out of. Anyway, not much is lost anyway. So the second part of Rangika's question regarding the KK's kabushiki gaisha and GK, which is Godo Gaisha being the close corporation form that I allude to for Japan's case. So I did make an observation, and I still do, that for the longest time, KKs are more preferred. The balance is shifting a little bit, because to incorporate the stock corporation, right, the KK, they actually require a notarial form. Not quite as complicated as the German version, but it's an additional fee. It costs more to start up, and there's an expectation, notwithstanding the loss of relevance of capital maintenance, for KKs to have very high share capital. Right, like if you have like a 1 million yen and share capital, people are going to look at you like, what is this joke? So you might as well incorporate as a GK. There's not much loss, right? If you're going to start up as a KK, you better have like 100 million yen, which is like about $1 million Australian dollars, right, in registered capital. Then it looks respectable on paper. Now we know that it's quite pointless, but that's how Japanese society continues to function, based on my conversations there. Though I can't prove it on a qualitative basis. So it's true that KK is somewhat preferred because they look more respectable, but I think people are increasingly realizing that it doesn't necessarily make sense, and that the new GK is to some extent gaining popularity, albeit starting with certain sectors like I think apparently hair salons find the GK quite useful, and also like real estate businesses. So it's spreading, right? I think those who are in the know or who are advised properly will consider using it. So I hope that addresses. I would love to carry on this conversation because I'm so happy that someone's interested in Japanese corporate law. This is it's not something I come across every day. So please, I shall restrain my enthusiasm for now. And welcome back, Martin.
Thank you so much,
Okay.
Alan.
Thank you, Rangika.
Thanks, Alan, and good to see that we have Martin back. So can we hear from you now, Martin?
Maybe let me talk about a few things, and I'll use my slides as notes, basically. So basically, I thought there were so I'm really I'm really impressed by the book and by your language skills, using sort of really getting in depth into this. I think this is a very interesting topic because it involves a very difficult trade-off, right? On the one hand, minority shareholders, they have to be protected against oppression, freeze out, maybe even potentially unforeseen circumstances outside of their control if we use your insurance model. On the other hand, withdrawal involving a payout also creates risks to business, right, in the form of hold up, payment to because a payment to departing members has to be made, and often, as you said, it is made by the company if it is not hindered, by capital maintenance, for example, I think, which you talked about. And maybe even the loss of the contribution of the member. So for that reason, I would be very cautious in permitting at-will withdrawal. So I think this is something we have to be very careful about, and I find that very difficult. On the other hand, there is, I guess, this efficiency question when you go from the ex post to the ex ante level. What are the expectations of the parties going into this, and what are the best incentives to make people join the firm? And there, I think the question is, how do you write the best law, right? And what is the best mandatory law, the best default law? If I were in the position to write an operating agreement for an LLC, for example, I have a book with operating agreements and the DVD from the New York State Bar Association. So I would probably use that, or something I find on Westlaw or something. So on one hand, you could imagine that a lot of people use that kind of thing. In a relatively unsophisticated context where maybe a lawyer comes up with something, I doubt that parties are very likely to bargain about withdrawal. So I wonder what that role plays for your theory, and to what extent because for that reason, I think defaults are always going to be sticky, and they're really going to be important. On the other hand, you might see unbalanced bargaining positions. So I've really recently seen an operating agreement with an LLC, so where somebody had an LLC, a business run as an LLC, and he hired someone and admitted that person as a member. He said, "You'll get 20% of the profits. You will work here," and the agreement was already here, and it was totally lopsided. The founder of the business, had all the powers in the world, and the guy who came in, he was not very sophisticated. He was in no position to bargain, so he just signed this. I mean, he didn't get his 20%. They only gave him 11% of the profits every year. It's not really clear why. And then eventually the owner, the 80% owner, fired him as an employee. So this all ended badly. But in that kind of situation, I think even if you're a contractarian, you probably will want to have some kind of mandatory law. So that was what I was thinking in that example. So the other thing I wanted to talk about a bit, if I have the time, is a big question that we often raise in comparative corporate law, which is why the law took the shape that it has, right? What are the reasons for it outside of, random things? But usually we talk about these things in the context of publicly traded corporations. So we talk about, maybe legal origins, legal family theories, and I wonder to what extent the legal families play a role. The insurance model and corrective model distinction seems to run across these lines, right? Civil law versus common law. But for instance, not the at-will withdrawal question, right? Where at-will withdrawal seems to be on the way out in the US, in LLCs at least. In Japan, it seems to have come in. So that's also very interesting. And relatedly, sociocultural theories, you could probably come up with some of them. The other question I was wondering about were whether political theories of corporate law play a role here, because it seems to me, I'm sort of thinking about this for a few minutes or a few hours. I was wondering to what extent is closed corporation law political? Are there any coordinated interest groups that might benefit from specific laws? It seems to me that the interest groups that are strongest here are maybe legal professionals. So in civil law jurisdictions such as Germany, I don't know about Japan. You would think about civil law notaries who have money to make from early on when the entity is founded, maybe in the context of a transfer of membership interests, but not so much at the time of withdrawal or dissolution. So I wonder if this is a politics-free zone, maybe as an area where so efficiency can come in, and we can have convergence and competition roam freely, if you will. Whether that might be a reason why we are seeing this convergence to similar models spontaneously with relatively little direct copying. I would be very curious to hear about what your thoughts are. Of course, the counterpoint to convergence is always path dependence. There are political reasons, economic reasons, so interest groups especially that prevent convergence to an efficient model, but there could also be doctrinal reasons. So doctrinal path dependence, because legal professionals or people who write law in particular systems are familiar with them, or judges are familiar with them. And I was wondering, for instance, this in your discussion of the German law, for example, general principles of long-term contracts clearly play a role. And that might explain solutions and sort of lead us back to a legal theory. So as some of you may know, while I teach in the US, I'm originally from Austria, and where the limited liability company law, the GmbH law, is from 1907. Usually nobody is interested in it, but for this topic, it does not allow a withdrawal, even for a good reason, and it does not allow a dissolution petition for cause. At least the statute does not allow it, but all the scholars are saying, it should allow it, and they've been imploring the Supreme Court to allow it. The German law has it. Why don't we have it? So this is terrible. And general principles of long-term contracts require it. So please, Supreme Court, allow it. But the Supreme Court has remained stubborn. So because, when they wrote the law, they knew what the German law was, but they still did not implement it this way. But still, my point is, I think these general patterns of law are also often something that influences the development. And I'd be curious about what you think about how this plays a role in your topic. So I apologize again for all these technical problems. In 3 years of online teaching, this has not happened. But Alan, congratulations on a great book. It's going to be the standard reference work for this topic for a long time to come.
Thanks so much, Martin. We're glad you made it back, but sorry to hear that you've actually presented without knowing you were disconnected. Alan, would you want to respond to that? We still have, the event is supposed to run up to 11:15, so we have time.
Thank you, Martin. You're really very kind. I apologize for having you to repeat what you have said just to an audience of one. And again, as always with Martin, I think the big issues that you raise are something that I've thought about, but if I didn't address it in the book, it's actually because I don't actually have an answer I was confident in writing about. But since this is a discussion setting, I feel more liberated in sort of sharing what I thought about it. So the question of political theories, right? So I think it's very interesting that that there's no clear foreign influence, and I think, and once Martin was talking about, which are the interest groups that would benefit from the status quo or from obstructing reform, it occurred to me that perhaps close corporation law is one of the areas in our field, right? Corporate law and governance more broadly construed, where politics tends to play a marginal role. It's not a politics-free zone. Unfortunately, I don't believe that anything involving humans is politics-free, but I think it's true that the interest groups involved don't really involve economic actors. The businesses that close corporation law regulates don't really have the ability to organize at that level. So it's played through proxies, I guess, scholars who favor one school of thought versus another, judges being another very important interest group. Though that's probably, is that inappropriate to say so? I mean, they are, right? Broadly construed, right? And because they actually do the work. In the court side, right? Of course, legal practitioners who should be the first port of call in resolving things consensually or through mediation or alternative dispute resolution, as Pamela correctly, I really support that, pointed out. They're all interest groups. But insofar as we look at the history of how withdrawal evolved, the driving actors are different for each jurisdiction. So in Germany, I think, as Martin sort of alluded to, it's the scholars who are very excited about this. The judges sort of, probably because they did their doctorates under these professors, they kind of like, internalize these ideas or influenced by expert opinions written by professors, because they have this culture much more so than Anglo-Commonwealth jurisdictions. So I think it percolated in a little bit. So that's a form of influence, in a sense, by the professors on the judges. So insofar as the judges feel like they are free to create something where the statute does not mention anything, right? Then if the culture allows for this is one way by which withdrawal can be developed. There's one way through which political influence kind of worked. In the UK, the judges were actually the problem. They kept refusing to deal with close corporation disputes. So Parliament stepped in twice. So I think that's the clearest example where Parliament actually had a will on the matter and actually did something about it. And the first attempt, the 1948 statute, which judges didn't really apply as aggressively as they should in the early years, is the forerunner of the oppression provisions of, I think, Australia through the Victorian Companies Act, Uniform Companies Act, and now the Corporations Act, if I trace the genealogy correctly. Same thing for Singapore. We all trace our descent to the 1948 UK Companies Act. Right. So that is a situation where, oddly enough, Parliament acted without too much consideration of the usual interest group politics. And perhaps because it was perceived as a technical law, and the reports came out of the Board of Trade, which is the forerunner of today's well, in Australia, ASIC, but ASIC does a lot more things than just that. But the Board of Trade was the companies regulator in the UK back then. So it was kind of a bureaucratic, I guess, neutral, perhaps in a way, source of influence. So the social cultural theories aspect, I fantasized about writing about it, but I just didn't have the data to back it up, because I think this is the sort of thing that I'll be careful with speculating unless I had qualitative data. But it's really difficult, right, to come up with this. And actually, when I was doing my research, my supervisor told me, do you want to interview notaries? I can probably make this happen. And I was really tempted, but I figured, okay, I could do it perhaps for German notaries, but what about the rest of the world? What are the equivalents? Right. So who are the groups that I need to talk to? Who has the pulse, right, on legal culture? So I think I just gave up when I thought about that. But maybe in the future with a huge research grant and a team of students, I think this is something worth exploring. Is there differences in business culture in each jurisdiction? And should the law reflect this, or should perhaps the law be a technical instrument flawed because of access to justice concerns and costs, but perhaps just there in the background, because it's a bit unrealistic, and perhaps as corporate lawyers, we want to make ourselves important, right? That's our interest, but we cannot save the world with corporate law. It is not everything in the world with corporate law, much as we want to hope. So perhaps withdrawal, like and most parts of close corporation law, should perhaps be a little bit detached from reality, but it should be correct. It should work when called upon. But ideally, like divorce law, we shouldn't have to call upon it unless we have no other choice. So I think that's something to consider. I'll probably think about it for the rest of my life to some extent, but never really get around to it. So doctrinal path dependence, I think Martin alluded to thou should held this, right? Which of course I tried reading this stuff and in some detail. I gave up past a certain point because man, the stuff out there is just incredible, right? So again, I think this is why I did caveat myself when I wrote about the model remedy. I said that the implementation of it would really depend on the legal ethos, right? The existing doctrines in recipient jurisdiction or implementing jurisdiction, and that's why the copy pasting a statute is not going to work. It has, I think, a model law that the receiving jurisdiction then debates over. It's like, hey, does this fit with us? What are some of the doctrinal tools we need to develop to make this work? Or how does it fit in? Do we change some of the words? Do we eliminate some parts? That's a discussion that I think every jurisdiction should have carefully in law reform. Perhaps at least amongst professionals, scholars, practitioners, judges, perhaps even if this is the sort of thing that doesn't really lend itself to open democratic participation as other more overtly political laws, and there are many of those. So I hope this deals with some of the big issues. As to the smaller issues, I think I struggled with the realization that people are just going to ignore this and they won't bargain and they might use cheap resources or just standard forms, right, drafted by lawyers. I think this is inevitable, which is why the sticky defaults are designed in a way that actually, if you use a standard form without thinking too much about it, it actually doesn't fit the criteria. So the default protections still remain. I think this is my way of trying to say that if you want to contract out of it on the cheap, it's not going to work too well, right? And really only if a lawyer sits you down and tells you, you know what you are getting into, right? You know that the consequences of contracting out of this particular provision are, have you, and these are this is what I'm going to follow. Are you really sure? Without going through that process, I think it should not be permitted to contract out of the sticky default. I think on that level of warning, like what Lord Denning used to say, the big red hand on the contract, for those of us who are from that tradition, right? I think an equivalent of that should be a prerequisite before contracting out of the protections of a good, well-designed withdrawal regime. So with that, thank you. Sorry, I think I spoke a bit too long, but back to you, Akshaya.
Thanks, Alan. I think I just taught that Lord Denning case a week ago. Anyway, any questions? Peter.
Oh, thank you. Look, this is fascinating discussion. I'm so excited about the work that you're doing, Alan, and I haven't unfortunately had a chance to read it, but the commentary has been extraordinarily interesting as well. So thank you for the discussion. One of the things I thought about that might be worth reflecting upon is the point that was made by Pamela about whether a potential interest group is the interest group collectively of women that are involved in these close corporations, because we can see, at least in Australia, a quite strong movement by women generally to be thinking about their roles in economic structures. It's occurring within the context of pay in particular, but I think it's because a lot of people just haven't made the connection between the involvement of women in small business organisations and particularly their role within close corporations, particularly because of the prevalence of business risks, equating it to the separate personality of the corporations. I wrote about this 1,000 years ago, but it's still in circulation, and it's still, the two issues haven't really been connected up. So that's one source, I think, that could be quite interesting, but there are many others to think about. So again, I thank you for your work.
Thank you, Peter. That's Professor Peter Spender at our law school. Any other questions? I might just ask one of my own to all of the panelists if there's no other questions. No? Okay, so Pamela mentioned equity crowdfunding, right? So I was wondering if now with more, it's getting popular in the US and UK as well. So would those crowdfunding platforms perhaps serve as interest groups? And would that be the driver of corporate governance competition across jurisdictions? Because there you can actually choose your jurisdiction as against mom and pop shops trying to register locally, right? To any of the panelists in Anna.
I'll go first. We do allow proprietary companies now to raise funds from people who aren't insiders through this mechanism. I think it's a really good reason for us to develop a proper closed corporation statute that doesn't include companies that have shareholders of that character. I think part of the complexity in our existing Corporations Act here is because we try and adapt, you know, a sort of standard form, and then we embellish it to allow it to do other things, rather than going back to what we successfully did 100 years ago with the proprietary company and the no liability company, which is to devise different corporate forms that suit different arrangements. I think closed corporations, that's why I put that definition up at the beginning. We need a solution for entities where people have a kind of Ebrahimi type expectation of involvement in management, because I think they do raise different issues. If you're a passive shareholder, then you should be exited on exactly the basis that you deserve, which is if you invest in something and it's not going the way you like it, you can either sue the directors or you can forfeit your investment. I think closed corporations are a different case, and so that's why I continue with no hope of success to advocate for resurrection of our poor old closed corporation statute. So, and I think, so in answer to your question, I think the fact that we now do open proprietary companies in Australia to external shareholders means the case for that is even more compelling.
And if I may just add on to that, it's a bit unusual, but perhaps Japan's experience may be of reference, because in Japan, the Kabushiki Gaisha, the stock corporation form, was actually used for really small companies for many decades. And it's only very recently that they actually came out with a closed corporation form that resembles, actually, I think to a startling degree, the abortive closed corporations bill that you discussed. And I think the difficulty will be to move the millions of existing proprietary limiteds, at least a few 100,000 that are multi-member closed corporations, to the new form. Are you going to have a transitional thing, or just wait for history to correct itself? I think it's really a process that will take decades, and we're already almost 20 years into the Japanese experiment, and it's still slow. So really, it may be something that will last beyond our lifetime. But I really do agree with what Pamela is saying. Now that I think the notion that one company form should do everything, should be all things to all people, I think is unrealistic. And we should try and separate by form, which is ironically the European tradition anyway, although it's not always worked out very well. And so one word about what Peter has said. So I completely agree with this. And in fact, there was a very interesting article about how oppression law in the US is actually feminist. It's actually pro-feminist because because it acknowledges sweat equity in a way that other regimes of neoliberal corporate law does not. And I think this is an absolutely important point. But what I'm actually concerned about is, at least in the Asian context, women are not necessarily even given shares, despite their contributions. And in patriarchal enterprises, some of which still persist, surprisingly, women are excluded from management ex ante. even if they're given shares. So the treatment of different participants, even within the same family enterprise, can vary on context. I think that comes back to the social cultural explanation aspect of this. And I think it's really difficult to come up with a law that is all things to all people, like again, but perhaps as a start, so recently I was attending lectures in the Netherlands, in The Hague, and Professor Kermit Roosevelt, talking about the third restatement on the conflict of laws, said that we should endeavor to decide simple cases correctly and hard cases simply. And the model remedy, I think, tries to offer a simple answer to hard cases. When in doubt, permit withdrawal on pro rata basis with no minority discount. I think that as a starting point, so long as there's a shareholder status, the hook, that confers standing of various interest groups to seek recourse to the legal process, I think we have something to work with. But if they don't even have that standing, and I think we're seeing this with stakeholder standing in public interest litigation, etc., I think it's still a difficult, it's a really tough sell for corporate law, given the much stronger interest groups standing in our way. Thank you.
Thanks very much, Alan. I think we're at time, so I'll thank Alan, Martin, and Pamela for giving up your time and making this such an interesting session. And thank you all to our audience, and the discussion was great too. Thank you.